My office handles crash cases across Florida every week. The ones that tend to stick in my mind are the ones with dash cam footage, because Florida drivers on camera tell a story that is impossible to dispute. Recently, someone on my staff shared a collection of Florida dash cam clips circulating online. Most people watch and think unbelievable. I watch and think I have sat across from families hurt when someone did exactly what you are about to see. Today we are reacting to some of the worst Florida driving caught on dash cam, and I will tell you what I see from a legal standpoint. I'm Doug Burnetti with Burnetti PA in Tampa. Let's get into it. Why Florida dash cam footage matters legally. Before we get into the clips, I want to give you some context for why this footage matters beyond entertainment. Florida recorded nearly 400,000 crashes in the most recent annual reporting period. That works out to roughly one documented crash every 8 seconds around the clock. The overwhelming majority of those crashes involve at least one driver who violated a traffic statute. But violation is easy to assert and hard to prove when it is one driver's word against another. Dash cam footage changes that equation entirely. It creates a time-stamped visual record that insurance adjusters, attorneys, and juries can watch. The driver who claims they signaled, the driver who swears they had the green light, the driver who insists the impact was minor. None of those claims hold up the same when a camera was rolling. If you drive in Florida and you do not have a dash cam, I am going to make a case for it by the end of this video. Let's start with the footage. Clip 1, the aggressive multi-lane move. I want to pause right here. What you just watched is a driver making multiple unsignaled lane changes in a matter of seconds on what looks like an interstate during peak traffic. Let me tell you exactly what I see. Under Florida Statute 316.155, the driver is required to signal their intent to change lanes no less than 100 feet before making that move. Not as a courtesy. It's a legal obligation. Every lane change you just watched violated that statute. Now, here's what matters in liability context. Florida uses a modified comparative fault system under Florida Statute 768.81. Fault is assigned as a percentage to every contributing party. If you are found more than 50% at fault, you may be barred from recovering anything from the at-fault party. A driver who makes 3 unsignaled lane changes in 4 seconds is going to carry a high percentage of fault in any resulting collision. But notice what the vehicle that almost got hit does in response. They accelerate into the gap rather than giving space. That matters too. If you are ever in traffic with someone driving like this, give them room, let them go. Do not engage and do not match their aggression. How you respond to someone else's reckless driving can become a factor in your own case if a crash occurs. Clip 2, the red light runner. This one is different from the first clip. The first clip was aggressive. This looks like inattention. The driver is not running this light to make time. They simply did not stop. That distinction carries legal weight because the distinction between ordinary negligence and gross negligence affects damages. Under Florida Statute 768.72, punitive damages are available in cases of intentional misconduct or gross negligence. Running a red light because you were momentarily distracted is ordinary negligence. Running a red light because you were looking at your phone or because you simply did not care about the signal is moving towards gross negligence. The gap between those two findings can be significant money in a serious injury case. The practical takeaway from this clip. A green light gives you the right of way. It does not mean it is safe to proceed at full speed. I teach my kids and my grandkids, I tell my clients the same thing. Look both ways before you accelerate through a green. That habit has prevented catastrophic crashes. An intersection where you have a green light is still a place where you should be watching for someone who is about to do exactly what you just watched. Clip 3, the on-ramp merge failure. On-ramp merge crashes are among the most disputed case types in Florida PI litigation. This clip shows exactly why. Under Florida Statute 316.085, a driver changing lanes or course must determine that the movement can be made safely without interfering with other traffic. For merging drivers, the practical obligation is clear. That is clear. But watch the vehicle on the highway. They have room and they accelerate instead of adjusting. Here's where comparative fault gets complicated. Yes, the merging driver has the statutory duty to yield, but a driver on the highway who had the time and space to avoid a collision and chose to accelerate instead may bear some percentage of responsibility too. Insurance adjusters will argue both sides, and the dash cam footage is often the deciding factor in how that percentage gets assigned. I tell people this all the time. On a Florida interstate, merging vehicles are your problem to manage. You see them on the ramp before they see the gap. You know the traffic pattern. The person merging does not always have a clean sight line. Giving an on-ramp driver room costs you nothing. The alternative sometimes costs a great deal. Clip 4, the expressway rear end. This one gets me every time. The car in front slows down. There's nothing sudden about it. It is just a normal, gradual deceleration. And the car behind him hits them with no apparent braking at all. Under Florida Statute 316.0895, every driver is required to maintain a safe following distance for their speed, road conditions, and vehicle type. What you just watched is a textbook failure on that requirement. Here's what most people do not realize about rear-end collisions in Florida. Even when the following driver is clearly the responsible party, their insurance company is going to probe everything they can to reduce the payout. Was the lead vehicle's brake light functioning? Did they stop suddenly for a non-emergency reason? Were they the cause of a traffic backup? Those questions do not change the fundamental liability picture much, but they are the arguments that get made and they affect negotiation. Your brake lights need to be working, and if you are hit from behind, document the skid marks or the absence of them, because that evidence tells a story of whether the driver behind you ever even attempted to stop. What every one of these clips have in common? Every clip we just watched shows a clear legal violation and a clear potential injury event. The reason dashcam footage has changed personal injury litigation in Florida is simple. It removes the he said, she said dynamic that insurance companies use to minimize claims. An adjuster cannot tell you the impact was minor when the camera shows a full speed T-bone. A driver cannot claim they had the green when the footage shows a signal was red when they entered the intersection. If you drive in Florida, a dash cam is one of the smartest investments you can make. Not because you are looking for drama, because when someone else causes a crash and denies it at the scene, you need the evidence that holds up. A decent front-facing dash cam costs less than your insurance deductible. Keep it charged and know how to clip and save footage before it loops over. Have you ever caught a close call or crash on your own dash cam? Tell me about it in the comments. What happened and how did it affect the outcome? I read them all. If you want to understand what Florida's fault rules actually mean for your claim when another driver causes a crash, we cover that in detail on this channel. Check the description for the link. I'm Doug Burnetti with Burnetti PA. Thanks for watching, and I will see you in the next one.